in this matter. We are not, I'll let Ms. Cleo take the wheel on that.
Ms. Cleo, normally, of course, as you're probably learning, we adhere to quick, very strict court procedure. However, we haven't been able to trim and transport several hearings. So as you're incarcerated without any opportunity of the otherwise freedom to participate, I'm going to make an exception and give you a chance to kind of express your concerns. Just understand it's not to set a precedent that I can allow that every time, because there's court rules and procedures for hearings. But yes, go ahead. Tell me what you'd like to hear.
I do not believe that the shelter care should continue. In regards to CPS states in their declarations that my 3 sons remain with my husband as for familiar relations, which is true and accurate. He has been the father to all of them, even though he has not fathered them biologically. The same with Arabella, he has done so. And they don't open a case against my boys, but they open a case against Arabella. They are clearly biased, and Miss Wiley, Beth Wiley, has threatened me if I bring this up in front of the courtroom that they would open a dependency on my son, which that doesn't make sense. Like if they have not opened a dependency on my son, Liam, which his father was incarcerated here with me, and I was here, so both parents unavailable, same situation as Arabella is in, both parents unavailable, but they allowed Liam to stay with my husband. And my position is Arabella should be placed with my husband and no shelter care even take effect. That doesn't make sense if what's good for one child is good for both children.
Understood. Appreciate you airing those concerns. There's actually a number of layers to what you're having to say, and it's kind of legally, I want to say it's overly complicated, but there's a number of laws that come into play. So succinctly put, once a petition for dependency has been filed, it needs to be adjudicated. That's what the fact finding and disposition will be. So much of what you addressed today will be relevant for that proceeding. Shelter care, however, is for the unique circumstance until such time as the court makes the finding on dependency, and if so, on disposition and placement, is simply the placement of a child. And so in that sense, there is proper jurisdiction and authority for purposes of placement. I think, and I understand what you're saying, but really where your argument can be heard and can be considered is going to be at the fact-finding hearing, okay, for placement purposes, because in your case with Arabella, you're the only physically available parent, except you're not physically available for incarceration. So that's the reason why for shelter care, it's very, very narrow in scope. It does have to be continued, but your thoughts and considerations will come into play through testimony and otherwise at the fact-finding hearing. Does that explanation make sense? I know it's not going to be satisfactory to you, but does it make sense?
Yes, Your Honor.
Okay. Ms. Khalil, thank you very much. I appreciate your thoughts. I am going to enter order continuing shelter care. We are going to continue. Let's continue it to the 15th. And then if there's ongoing concerns regarding active efforts that apply, this will be reserved and you can have that heard at that time. If there's going to be any type for the court's review, any reading outside of our normal amount, which is about 25 pages total, you need to let the court know. As you can probably be well aware, if you file, and I'm not saying you're going to do this, but if you did file something just days in advance, I'm in hearings every day, and almost most of the time when I'm in hearings, I'm involved in hearings that have 200, 300 pages of reading per day. So to get short notice to read is not going to happen. I just want everybody to be really transparent and upfront with you, because that's why we have the procedures and rules that I know you always try to adhere to. But in this circumstance, if you're going to file something and ask for deference and consideration, but it's based on volume of read, our schedules don't permit that right now. Every area of law, dependencies, family law, protection orders, and domestic violence cases is such a high level of expectation and need right now that we're doing a lot of reading. I'm not complaining, but it's saying I can't read something a day or two in advance that has a lot of reading. I need the normal time frame to read, okay? So please keep that in mind as you decide what you feel is necessary for the court to consider.
Your Honor, so I did scratch out the active efforts box and said reserved for fact finding or hearing on 8/15. And then I checked the active efforts have not been found, reserved for hearing, for fact finding hearing or hearing on 8/15. Releasing the child to either parent or the parent would subject the child to substantial and immediate danger or threat thereof.
Correct.
Okay.
Yes.
And Your Honor, I do want to note that we would like you before the 15th to read the documents that we provided today. I know it's quite lengthy, but just because you just asked for notice that you would like those, if you would like those read. So
Yes.
thank you.
So you put me on notice. Right away. Smart move.
Thank you.
Say for Mr. Murray, I know you're gonna do a response with Ms. Khalil, so I know that's coming, but what I would suggest that you do, don't only email it to the dependency box, email it to my general judicial box. That one I look for everything. Dependencies, I try, but there's so much to read. So if you put it in my normal box, I'm gonna see it much more, well, I will see it. Dependency box, maybe.
Your Honor, may I say one more thing, please?
Yes.
I have asked this court, I've put them on notice that I did not want my child in any type of church or religious gatherings. And the department says that I have to have a court motion to do that. That doesn't make sense to me because it's my child. I'm the only one that has legal rights to her. And so if you could at least put it in the paperwork today that she cannot attend any churches or religious gatherings, that would be muchly greatly respected. Because that family is bringing my daughter to church every week, and I don't agree with that. And CPS says I have to have a court order. Well, I don't want to wait another month for my daughter. She's had 3.5 months of their religious practicing brainwashed into her head, and I don't agree with that. I don't want to have to wait another month.
Bill, thank you. Mr. Murray, I know that was part of the declaration on active efforts, but I think that permeates more the statute than just the issue of active efforts. And Ms. Williams, do you want to just sua sponte respond?
Thank you, Your Honor. I think there are two separate statutes that would, or separate issues that would lead directly to this. Number one is prudent parenting. When a child is placed outside of the home with a caregiver, prudent parenting is put into place by statute. And that's so that foster children or children out of home care don't feel othered. So in this situation, cousins, aunts and uncles, grandparents are all going to this service. And now you're saying that this child has to be othered and feel differently. And so that's kind of the whole purpose of prudent parenting, is to not other children in the process. Number two is that due to Judge Begg's decision of sole decision-making being with Mr. Daniel and his family accessing this religious avenue, I don't have the information before me of whether he also was involved in the church, but it's a logical conclusion that if he had sole decision-making, which he did, that she would be involved in the church. And so that would have been something that he would have been able to do. And he's not here to put his position forward. But Judge Beggs did find, by numerous reasons due to domestic violence, stalking, an emotional issue, that Mr. Daniel had sole decision-making. And so Arabella probably likely, without putting the family up to testify, one could logically assume that she would have been involved in those religious activities anyway.
All right, so the issue of
Would I have a chance to just respond very quickly?
you can go ahead.
I just want to know for the record that whatever documentation that Ms. Williams is referring to is from a previous family law matter that's buried in about 203 different PDF files that was only recently disclosed to me. So it's a little difficult to respond to specific family law decisions that were made previously. I also want to note that I think that a new dependency will usually trump previous dependency law matters. And I just want to know for the record. I know it's a it's a complicated issue, which is part of the problem doing it ramshackle like this.
Her father did not take her to church, Your Honor, for 2.5 years. She did not go to church.
At this point, let me regain control of the courtroom, please. And I'm considering what you're saying is a very, very serious and important topic. We all, of course, know statutory provision that Ms. Khalil is talking about, whether she knows it or not, but she's hitting one nail on the head, which is the parents' wishes should be taken into consideration. That's what she's saying. And I understand, that's why I said it's complicated. It's complicated because there are other aspects of how it may affect Arabella based on the prudent parenting, but also the family law and the reason why it may be relevant. And I don't know. So understand what I'm about to talk about. I have no knowledge. I have no understanding about the orders when they took place, what Mr. Daniels did or did not do to act on behalf of those orders, or Ms. Khalil for that matter. It's with no knowledge. So this is more of a, I think, an important recitation of what it takes for the court to make this kind of a decision, because a religious preference as expressed by Ms. Khalil, which clearly is contrary to what's aligned with the current placement. As you know, Ms. Khalil, and the attorneys know, if this were a family law matter, it's a very important decision on decision making for parents, right? So it's also important here. And in a family law case, that isn't something the court just dictates and answers. You have to file a motion. Ms. Khalil, I think a challenge for you, and I respect this, in your situation, when you're told something, you know, it's a little challenging, I think, to really put yourself in a position of gaining knowledge in terms of time. Mr. Murray, your attorney, is a very good attorney, but of course, he represents a multitude of clients. And so for you, you want the knowledge right now, as opposed to the likely time frame to acquire that knowledge. And what I'm getting at is that it is necessary for a decision of this magnitude to be pursuant to a motion, because there's more than one law that applies, and it's not something the court takes lightly, nor should the court take lightly, including incorporating preferential treatment as compared to other very equally important considerations as indicated to the court by law. Okay. And part of what is going to be relevant is that the parties, if you choose to, if there's an indication that there is additional family that has knowledge about what really took place in the real world, for goodness sakes, on this issue, and they want to provide a declaration now, irregardless of the umpteen pages in the family law file, these folks are here now, except for one person that we know, Mr. Daniels not here. He can't voice his opinion, but others can. So there may be others that have knowledge on this issue that's very relevant. And even on your side as well, Ms. Khalil, that's for everyone. So a motion needs to be filed for the court to make this decision, and understand, in addition, to add another layer of complexity, what's unique in dependency cases is that, I think this is often missed, I think even practicing attorneys, because it's not often we have to think about this, but the care, custody, and control of a child pursuant to law is in the hands of the department. Okay, there, if you want to look at it, the primary caretaker of this child delegated through the placement system. Okay, so inherent in that is some inherent decision making and authority, and for the court to intervene in that authority, just like with a parent, takes application of facts to law. It's not something that I inherently have more authority over you, Ms. Khalil, or you, Ms. Williams, Ms. Dees. It's something that I have to make a decision on, and it's predicated in law, and it's principled upon making findings of fact, which of course, through our legal system and the dependency system, is applying proper procedure, which means a motion and and declarations. So I wanted to provide that detailed explanation, Ms. Khalil, because it's contrary to what you would like and desire, and I respect that, but it's the law and it's the procedure that the court needs to follow. And whether you can realize it or not, in the grand scheme of things and the totality of the circumstances, it leads to the most likely thoughtful, intelligent, well-reasoned result.
I don't understand how the department states that they have done everything like active efforts when they continuously go against my wishes. They tell me that they have told the family to not post her online.
And that's what Mr. Murray will talk more about that, but I don't want to get into it much. It's partly in the briefing. Active efforts is a very unique legal standard, and in many respects, it isn't about the parental wishes. Now, they can overlap on the areas of law that is pertinent. So I'm going to leave it at that. I think I don't want to get too close into, I'm starting to comment on evidence. I'm not going to make that mistake. So that's the decision of court for today. Those issues you're talking about, Ms. Rodriguez, can be addressed with proper time to respond, whether on the 15th or in the fact-finding hearing, because active efforts will be raised in the fact-finding hearing. And if I reserve it today, you don't lose the ability to have it relate back in time, to this time period for review, okay? So, and that may be more prudent practice, but that's up to the two of you to decide in that area. Now, before we go, just logistically, when we're going to have a judicial assignment to a judicial officer, that's a judge, once you get into their schedule, as you all hopefully know, you're going to be subject to the court's calendar, their availability, and I know not what that is. So be prepared for that. Well, ideally, of course, we hope this matter goes forward with both. I don't know that, and you should be prepared to discuss that with the judge and their availability. It transfers, and the attorneys know that, and Ms. Khalil might not know that. So I want to say it really for your benefit and family too, so you understand, because you're in the background all going, what is going on? How does this work? This is a new area of the world to us that you don't know, and I respect that. So that's the procedure and the explanations on those particular issues. Trying to make sure that. So yeah, you'll see the email go out on, well, it's actually already been sent as it relates to the brokering policy. We still need to address the issue that Ms. Khalil firmly objects to, which is whether or not the case assignment for commissioner purposes should be transferred because of our Unified Court Family Act, Unified Court process to Commissioner Russa or not. So I'll send out an email, expect an email to go to all of you, and I'll be inviting positions, and Ms. Khalil's will be conveyed again formally through Mr. Murray in terms of her objection. Then once you get that back to the court, Commissioner Russa and I'll, pursuant to our policy, will confer and make a decision. In the grand scheme of things, I think this is the less in priority of a decision to make, as much as getting your case heard before a judge on the fact finding and get that done. But I wanted to make sure you're aware that still needs to be ultimately resolved. I'm just, it's not as important as so many other things that are taking priority right now.
Your Honor, can I say something one more time? So the department keeps speaking of that I got a stalking charge because Justin, no, stop. I don't care. Stop. However, there's 2 videos that I submitted into evidence
Ms.
that
Khalil,
stop.
No,
No,
you said no.
I don't care.
Don't bring.
But I think what he's trying to help you do, Ms. Khalil,
I understand, but I just need
before
you.
you talk, well, this is me and you,
Okay,
not Mr.
sorry,
Murray.
sorry.
Understand that when you're facing criminal charges, stalking is one, and very important, serious charges, correct? Homicide.
Yes, Your Honor.
Anything you say in court can and may be used against you as evidence, and you have a constitutional right in any proceeding, civil or otherwise, to exercise that right to remain silent. If you choose to waive that and you comment and you make statements against your interest, understand that a prosecuting attorney has every right to get a copy of this transcript or any transcript and use that in court. And that can very potentially be to your detriment, maybe not. But I want you to make sure you understand those rights. And that's what Mr. Murray is wanting to make sure you understand, because it can have some very, very significant repercussions.
Yes, Your Honor. However, because Commissioner Ressa allowed two videos into evidence where where Justin accused me of saying very direct quotes to him and stop.
Well, Ms. Cleo, let me just put a
And that
stop
did
to
not
this.
occur.
Understood, but this is well beyond the purview of today. It's not even in front of me. I'm not even sure what you're talking about, but when it becomes relevant, it's not for continuing a shelter care hearing, so.
I understand that. Your
Well,
Honor.
I can't give you a platform just to speak respectfully. I
Okay.
understand your desire to do that. So at this time, the purposes of this hearing have been fulfilled. So I'm going to conclude our hearing. Ms. Cleo, I understand your desire to want to be heard on in anything that enters your mind from your perspective, but that's not the proper, I think, procedure. And out of making sure you're understanding to protect your interests, I'm going to take a recess. Thank you so much. And transport, thank you for everything that you do. She's ready to be transported when you're ready. And then I'm going to come back out for, I think, a 2 o'clock hearing that
2:30.
or 2:30. And I'm 5 minutes late for, but I'm going to give you.
All right. Court's in recess, you may be seated.
I review the thing with her real quick.
Sure.
Okay. So this is the order. Basically saying there hasn't been change circumstances. Reason to know. This is active efforts which you done. They have active efforts in the reserved. This order doesn't constitute an admission by the applications. Social workers. Jump through. Let me know what's in there. Let you copy this as long as you're. Do you have any questions?
All that paperwork they filed.
Yeah,